What's up, family? This is your boy Ivan Hall, the Credit King. Do you have a lot of medical bills on your credit report that has hurt your credit rating? Medical debt collections may become more difficult for collection agencies to collect, but they may be beneficial to debtors in clearing their credit reports. The privacy rule requires a business associate, collection agency or billing firm, to reasonably limit the amount of information disclosed for such purposes to the minimum necessary, as well as to abide by reasonable requests for confidential communications. This could be a loophole for debtors against collection agencies because collection employees often know less about their industry restrictions than does the debtor. This could lead to violations and eventually case law to support such violations. If collection agency employees are not careful, they could lose out on collecting medical debts by inadvertently knowing too much about the debtor's medical condition. Debtors who know how to protect themselves will use this provision to threaten collectors and gain the upper hand in settling the debt without it hitting their credit reports. Basically, debtors who discover that the collector knows their diagnosis and treatment will threaten the agency that their privacy has been violated. The agency, wanting to avoid unnecessary suits, will most likely agree to remove the negative entry on the consumer's credit report by agreeing to settle with such terms. Developed by the Department of Health and Human Services, these new standards provide patients with access to their medical records and more control over how their personal health information is used and disclosed. Congress called on HHS to issue patient privacy protections as part of the Health Insurance Portability and Accountability Act of 1996, HIPAA. HIPAA included provisions designed to encourage electronic transactions and also required new safeguards to protect the security and confidentiality of health information. Most health insurers, pharmacies, doctors, and other healthcare providers were required to comply with these federal standards beginning April 14, 2003. Past due debts on your credit reports can ruin your credit rating, but some of the biggest offenders are medical debts. They account for almost 1/3 of all collection accounts, and once they're sold off to collection agencies they become credit killers. Unlike a past due credit card, medical debt can be sold quickly to numerous collection agencies over and over. They are quick to collect for agencies because very few people dispute them. Well, take heart, you can lower the debt, settle the debt, and even remove it from your credit reports. So, before you pay that medical charge off, listen up. Believe it or not, a medical bill is much easier to dispute and remove from your credit reports than a credit card bill. Medical debts are rarely questioned by consumers, and this is a major mistake. Most medical debts are overbilled. Medical debts are also shipped off to collection agencies fairly quick, which means they land on your credit reports before you have even had a chance to review the bill. If you have received a medical bill or many medical bills, consider the following strategy to reduce it and keep the debt off your credit reports. Review the bill as soon as it arrives and look at every charge. Many times you will find excessive charges for procedures that you don't even recall. Contact the provider of service and ask for a complete breakdown of all charges, including all medication, X-ray, and lab fees. Call the provider right away and make sure all insurance information is accurate and that you are only being billed the portion allowed by your insurance. If the debt has been sold to a collection agency, send a request immediately to the CA asking for a validation of debt. If the debt collector has too much of your medical information, that could result in a violation of HIPAA and possibly FTPA for third-party disclosure. Protect your medical records by requesting proof that you signed an authorization allowing the medical provider to release your information to a third-party collector. This law is covered under the HIPAA Act, and if you did not authorize it, then the provider may have violated the HIPAA by giving your records to the debt collector. This may be a great reason to have your debt pulled back from the collector and sent back to the provider. If that happens, a collector is not authorized to report the debt to your credit reports, so be sure and check your credit, and if it's listed, dispute it. The collector is allowed under law to have information about you such as your name, social security number, and address, but unless you authorized it, a medical provider should not include your medical records and diagnosis to a collection agency. While you cannot sue under HIPAA, yet, you can file a complaint and better yet possibly have the debt canceled if too much personal medical information was revealed about you without your consent. Many consumers selectively read what they want in the HIPAA law and run screaming violations without understanding what a violation entails. Remember, a debt collector is considered a business associate under HIPAA and is allowed to use your information to collect a debt, but it is a gray area as to how much is too much information. It may be too soon to tell since the HIPAA amendments are new, April 2003, but apples to oranges that any portion of your personal medical records will no doubt be violations of privacy. Financial information and location should be all the debtor have on you, not your treatment and diagnosis. Unless you expressly authorized it in your signed documents with the medical provider, so again read them well. The key here is knowledge. Read the HIPAA before you assume the agency has violated your privacy and go get that money.